Okay, we are live. I'm really excited about this live stream today. This has been a brainchild of mine for a couple of weeks now. I really wanted to kind of lead up into Financial Literacy Month, which is happening in April. I wanted to backtrack and get everybody really a head start, a jump start, if you will, before we really kick into Financial Literacy Month. So I'm doing this every Thursday at 6 p.m. in the month of March. We call it March Money because you're going to march your money right into April and into the rest of this year. And in this first event, I'm really excited. I brought in a very big heavy hitter. She is excellent at what she does. And today we're going to just talk about estate planning. Now, most of the time when we hear the word estate, I think many of us think that that's just for rich people, people that have a lot of money, that are affluent. We think about people like Chadwick Boseman. We think about people like uh, Aretha Franklin, Michael Jackson, Prince, John Singleton, Nipsey Hussle, and most currently like Wendy Williams. Those are just a few. And there's one thing that everybody had in common with all of those people is they did not avoid probate court. And so tonight we're going to talk about how you can avoid probate court, but most importantly, how can you plan for generations to come and make sure that everything that you work for gets passed down and you keep the state out of your financial affairs. So, without further ado, I'm going to introduce Attorney Ebbay. Lioness, please introduce yourself to the viewing audience. Let them know what you do and why you do what you do and why it's important.
Sure thing. Thank you so much for inviting me for this opportunity. As he said, my name is Lioness Ebbay. I am an estate planning attorney, and that's what I specialize in. That's all I do. And a lot of people know a lot about wills, but people in general don't know about living trusts. And I actually do a lot of living trusts for my clients, wills, of course, and power of attorneys. I love doing what I do. And every now and again, I'll get a client that says, "Oh, but do you do marriage dissolutions or do you litigate?" And I say, "No, I like being a happy attorney. This is a great area of the law to be in. I feel like there's a huge impact that I have on the families that I get to help. And what I found in practice is that what's missing with regard to estate planning and the average person in my community is that there's a lack of knowledge. People just don't understand how important estate planning is in everybody's life, how relevant it is. So I do like to go out and do my talks, hold seminars, hold Q&A sessions, because people just don't know what they don't know. And power of attorneys are so important, living trusts are so important, wills are so important.
Absolutely, absolutely. I have a question. Janelle asked, Dietrich, will this be available to replay? Absolutely, it will be available to replay. I would not want to get all this information just in a live stream and then let it disappear to the internet world. This is going to be available for replay. So make sure you stick around. If you find this information valuable, make sure you subscribe to the channel. Also like this video as well. I'm going to leave Lioness's information in the description once this live stream is over with. So if you have estate questions and you want to contact her, feel free to do so. But if you currently have questions right now, feel free to put those questions in the chat because we're going to answer as many of them as we can within the next hour or so. So Lioness, I appreciate it. I do have a question actually,
Sure.
and this is something that I don't know if a lot of people understand what this means. So, can you kind of tell us exactly what is an estate plan and what kind of things should be in it?
Sure. Okay, so you sort of hit on it early on, and you said that people tend to think that estate plans are for the affluent and for the wealthy, right? But the truth of the matter is that at this given point in time, every single one of us has an estate. Why? We all have bank accounts, right? Um, Some of us have retirement accounts, some of us have really huge retirement accounts. We all have life insurance policies. A bunch of us are homeowners, right? So these are all assets. And most adults have assets, even if it's just a bank account. So once you are an owner of an asset or several assets, you have an estate. And that's why you need an estate plan, because things happen, right? What ifs happen all the time. I've got healthy people that just fall out and pass away from a heart attack. Um, People have to go to the hospital off of a bad car accident, right? And of course, people end up dying and we don't plan for it. That's what happened during COVID, right? A lot of people thought this was just some super flu, did not think it was going to turn into this huge several year affair of vaccines and all of this stuff. And what happened during COVID is a lot of people died without an estate plan. And what happened as a result of that is that the probate court system in California, they became very, very inundated. So, an estate plan also has moving parts, right? Depending on what you have in your estate, you may be a candidate for just a will and power of attorneys, or you may be a candidate for a living trust, a will, and power of attorneys. It just depends on what your assets are. For example, if you own real estate, if you are a homeowner, or maybe you're a renter and you are an investor in an apartment building with several of your buddies, if you own any portion of real estate, you're a shoo-in for a living trust. You must have that in place. Because if you don't have that in place, your heirs, your spouse, they're going to probate.
Perfect. Actually, we this is a perfect question right here. So we're gonna jump into this question right here. And Chris asked, "Is it better to have a will versus a living trust, or both?" Good
Right.
question.
Right. So there are actually a large number of people now that require both a living trust and a will, right? For example, I told you if you own any piece of real estate, you need a living trust and a will, right? If you have special needs children with disabilities, maybe your child is on the autism spectrum, you require a living trust and a will. If you have assets, say you don't even own a home, but you have assets above $184,000, you require a living trust and a will. And the reason for that is because if you, let's say you pass away and you have like 30 grand in a bank account and you've already got designated beneficiaries, or maybe you don't have designated beneficiaries, we can still capture that $30,000 with your will and an affidavit. But once you start creeping towards $184,000 or over that, the bank is going to send us to probate. So, it's I think best practice would be definitely to consult with an estate planning attorney so they can determine exactly what it is you need. But like I said, because the laws have changed recently and with Medi-Cal, the number of people that now need a living trust and a will has widened.
All right. So, and on those notes, so if you have a trust, you can put a will inside of it. That it's called a pour over will,
It's a
right?
pour over will. So it's I call it a catch-all. So the living trust, if you have a living trust, that is the star of the show. That's what dictates who gets what, who's in charge, what you do want to happen, what you don't want to happen. Because the living trust is in place, you're right. The will just acts as a pour over will because it doesn't really say anything except whatever I leave in my estate at the time of my death, whether it was included in my trust or not, I'm pouring over into my trust. I want it included in my trust intentions. That's it. It doesn't have alternate intentions from your living trust. It doesn't state alternate people that you want in place. It just says whatever I had at the time of my death gets poured over into my estate via my living trust.
Okay, perfect. And just so you guys understand, like it's important to not just have just a will, because what it does not do is decide what's going to happen when you pass away. So what I mean by this is your trust takes effect as soon as you sign the document.
Yeah.
The will only takes effect when you pass away.
That's why it's
So
called
if,
a living trust.
right. So if you pass away with just the will, here's an example. So I mentioned a couple of celebrities before. Let's talk about Aretha Franklin. That was one of the big cases. She wrote two wills for multiple properties. So when she passed away, she had, I think it was like three, maybe five sons, and they were trying to figure out who gets what based off of these two different wills. Well, that process went to probate court, and it took several years for them to figure out who was going to get what. Had she had a trust in place, it could have alleviated a lot of that stuff. And so this is why this is important that we're talking about this right now, because as we just left out of Black History Month, we talked about the generational wealth gap between white America and Black America. And part of that problem is, one, we don't get a big head start anyway, but two is we don't have the necessary knowledge a lot of times to understand how to pass that wealth down and then how to keep that wealth. So statistically, 90% of generational wealth is lost by the third generation. So if you're planning on leaving a legacy, like I'm a man of faith, and the Bible says a wise man leaves an inheritance to his children's children. Well, part of that inheritance isn't just the assets that you leave, it's the wisdom that comes behind it as well. So this is why we're talking about this today. Chris, ask another question. So Chris wants to know, how long is the average probate process?
So it really depends on what kind of assets are in the probate case. Let's just make it simple, right? Let's say it's like a home, one home, one kid. Okay. Um, Prior to COVID, it was probably a year and a half. After COVID, I would say double the process. And I only use the example of one kid in one house because the more players you add to the game, the messier it could get. Because probate tends to become this forum for your heirs to get dramatic, right? Things can get really messy really fast. Like, well, mom told me, because I loaned her $500,000 10 years before she died, that I deserve 70% of the house. So it's a really unfortunately big breeding ground for issues like that to air out in public.
Absolutely. And Chris, just to further go along with that, so there really isn't an average time. So when we're talking about probate, there's two ways that can go in terms of probate. You can have a full authority probate, or you can have a limited authority probate. Full authority is essentially the court really is not as involved per se. So like you have a personal representative, they take control and basically divvy out how all of those assets are going to work out in the estate. Limited authority, there's probably a little bit of dispute that's happening somewhere, and they're trying to figure out who gets what goes where, and all these things. So the court has to get involved. So you have, again, limited authority as to what you can do. Now, with the trust, kind of eliminates having to go through that probate process. So again,
No
this is why
court
we're talking about.
involvement.
Right. So this is why we're talking about why it's important to have proper estate planning. And again, this isn't for people who are just like, well, Dietric, I don't have, three houses and $250,000 stacked up somewhere, and I'm not doing all of these things, but you do have assets somewhere. You have something of value. And unless you make a plan, the state is going to make a plan for you. Now, I'm speaking specifically about the state of California because that's where we're at right now. But the probate process across every state almost works the same basically. If you don't have a plan, the state has a plan for you. And if you don't want the state to make a plan for what happens to all the hard work that you put in to acquire those assets and your plan for those assets, then you want to talk to an attorney and set up a proper estate plan. So, all right, excellent, good question, Chris. I do have a question for you. So, we talked about the will, we talked about estate planning. One of the things that I'm seeing, unfortunately, I have quite a few friends, some family members who have gone through divorces. Can you explain how divorce works in the probate or in the estate planning process, and just give us a couple of examples? Because I know of a few where a couple got divorced, stuff was supposed to go to the kids, then somebody remarried, and then that new spouse wound up being the beneficiary and kind of bumping the kids out of there. So can you just kind of walk us through like some examples of how estate planning would work for divorce cases?
Yeah. So my married clients, this tends to be an issue that comes up with my married clients. Well, what happens if we get a divorce, right? And so what ends up happening is that once your divorce is finalized, they issue like a divorce decree or a settlement order. And typically that settlement order will trump the living trust because it will distribute the assets of the marriage, the community property, right? Once that happens, that living trust that the married couple put together is now null and void. And so now whoever walked away with whatever it is, more than $184,000, piece of real estate, the condo, now each spouse has to create their own living trust. It gets tricky once spouses remarry. So what I'm seeing a lot in practice is that clients are on their second marriage or their third marriage. We have blended families. And then it becomes really, really crucial to get a plan in place because, like you said, you don't want everything to just go to the new spouse and then you cut your kids out.
Right.
Right? It happens. I've seen it with life insurance policies. I've seen it with homes. Um, and yeah, there's so many instances where people just kind of forget to redo their plan because life changed and people just get left out. Feelings are hurt. Of course, grieving over someone who's passed away is already a difficult thing. But then having to stomach the fact that, oh my goodness, did my father forget about me in favor of his new wife? That's
Mhm.
that's really tough to swallow, right? So, you know, I think my rule of thumb is people tend to ask me, "Oh, when should I get when should I revise my estate plan or when should I have my attorney look at my living trust?" And it's really when life happens, when life changes, right? Did you get a divorce? Did your spouse die? Did you get grandchildren? That those are good milestones for getting your living trust updated or getting a new one, especially with remarriage, because most people do want to protect their estates for their children, whether we're on our second marriage or our third marriage. We want to preserve some part of our wealth for our kids and our grandkids. You don't want to
And
cut one out.
right, exactly. And how easy is it or difficult is it to change things around in a trust? So let me kind of back that up for 1 second. So I know of two kinds of trust. There's revocable and irrevocable. Can you explain the difference between the two? And then when life does change, how easy is it to change what's in the trust itself?
Yeah. So there are a very few number of instances that actually call for irrevocable trust. And it is what it says it is, irrevocable. That means that you put it in place, and the only real way you can change it is through the court system, right? The reason people put irrevocable trusts in place is because we've got a disabled trustor, right? I just had one of those. My client was in a terrible, terrible car accident. So terrible that he's now paralyzed from the neck down, but he got awarded millions of dollars, right? And the only way he can maintain the millions of dollars for his upkeep is to form an irrevocable trust, because that's what you form for disabled people, right? Another one is for special needs beneficiaries. Sometimes we have clients that form special needs trusts, which are irrevocable, because they don't want someone to mess around with their special needs child's inheritance, right? And then another one is if we've got a taxable estate, right? So a taxable estate is like if you get wealthy enough and you don't do any wealth planning or asset planning, the IRS will hit your heirs with a 40% bill. Okay. For married couples, it's a little bit over 26 million right now. For single individuals, it's half that. So if you get above, let's say you die, you're married, you got $30 million. Most wealthy people will plan for that 40% tax bill. Most of them will. And they'll do it so that they form a revocable trust, and then they'll form an irrevocable trust for the monies used to pay off the IRS upon their passing.
Wow.
If none of these situations apply to you, right, and it's a very few, then you are a candidate for a revocable living trust. Why? Because you need to have as much flexibility to make changes during your life as needed. Because when you have a revocable trust, you can make changes anytime. You can change your beneficiaries, you can change your trustees, you can change your intentions. And you can do it 10 times a year, or you can do it once every 10 years. It's really up to you. But as long as you've got a revocable trust, it's really up to you when you make your changes and amendments.
Is it expensive to do that? Like, I'm pretty sure everybody wants to know, like, what's
It's
it going to cost me to set up a trust? And then
yeah,
if I have to change stuff, how much is it going to cost me to
yeah.
change stuff? And
So I'm going to give you an example. I have clients that will only change their lists of gifts, right? I've got a client who's an art collector, and every like 2 or 3 years, she changes her mind. Oh, the picture of the Blue Angel's going this way, and the sculpture's going that way. And these are, since she's just changing her list of gifts, very minor change. So it's a very minor legal service fee. But then what I'm starting to see is I've got these 90-year-olds, and they're all there. They're all there, sharp as ever. And unfortunately, you get to be 92, you get to be 94, and you start outliving a lot of people. Unfortunately, you may outlive your own kids. You may outlive your own successor trustees that you want in place after you. Or maybe your best friend that you chose to be successor trustee now has full blown dementia. So, what I'm seeing with these trusts is there's nobody to inherit from my 92-year-old, and there's nobody who is capable or alive to ensure that my client's intentions are going to get carried out. So, at that point, we have to start over, because my two biggest components that make a trust successful are missing. No one's going to carry out the trust, and no one's going to inherit it. So it's basically starting over again. That's basically like getting a new trust.
right. And so that's a great segue to the next question that I have is, how does somebody pick who is going to be the trustee over the trust? Like, what would make a sound decision in terms of the choosing?
So that's great, because a lot of my clients, when we first start out talking about, what do you see happening if you we're not even talking about dying. What do you see happening if you become incapacitated, like your
Right,
cognitive functions, right? Because everybody thinks when we start talking about estate planning, it's all about dying, but most people live long enough that we see a decline in health first,
right,
or before any of that dying and death happens. So my clients often have this misconception, like I have to choose someone who's related by blood. That's the wrong standard. That's the wrong step. You don't have to choose family. You don't. What I would suggest is choosing somebody who is responsible and trustworthy. Because let's think about this. The the person you choose, and we're not talking about spouses, okay? Let's say your spouse is already predeceased you, but the person that you choose is going to step in your shoes, write checks on your behalf, sign these checks, have access to your money, is able to pay bills with your money. Think about that. And that person does not have to be a blood relative. That person is just has to be the individual that you trust implicitly to not steal from your kids or your grandkids or whoever, your favorite niece or nephew. They just have to be trustworthy. That's it.
And that's a very important point because I've seen many times where somebody will say, "Oh, I'm going to leave this, leave my estate to my sister, and she'll take care of my kids and do right by them." And that
Yeah.
person transitions and the kids get left out to dry. So you just want to make sure that, as Lioness said, you're not just choosing somebody because they're a family member, but they're going to be responsible. Somebody who you really trust is going to have your estate's best interest at heart. Awesome. Oh, we do have another question. So Janelle is asking, if a married couple did not write up a will and or living trust yet because they thought they had time, then die, they don't have kids, who inherits their property and investments?
You know, it's crazy. This is a real life scenario. It happens all the time. I
All the time.
yeah, yeah. So first, it goes to your nearest. We have to start thinking about your nearest living kin. So it's like, did your parents survive you? Because if your parents survived you, it's them. They get it. If they didn't, did your siblings survive you? Right? Because if they did, then they get a piece of the pie. If it's not them, did nieces or nephews survive you? Right? So we just go down the line of the family tree. Um, if nobody, let's say you guys were only children, parents already died, there's nobody, state of California recovers. Yeah, state of California.
So if you're in the state of California, the state is going to get all of that. If
Yep.
you're in another state, chances are that state is going to get all of that.
Yeah.
That's just kind of how the process works. So that's why, again, while we're talking about why this is so important. So make sure you guys are leaving your comments, your questions are in the chat. We're going to try to get to them, as many of them as we can within the next, I would say, half an hour or so. Also, make sure that you are sharing this video out. If you know family members, friends, coworkers who could benefit from this information, tell them to jump on the live stream right now. And make sure you give this a big thumbs up if you're finding this information of mass importance and value. Awesome. Let's see. Okay. So we talked about special needs. We talked about divorces. One of the things that I wanted to ask you was, you mentioned before, so we had conversations before we jumped on the live, y'all. You mentioned working with John Singleton's heirs and kind of what that was like. Without divulging too much information, can you kind of just walk us through that process of like what happened, kind of some of the things that went into where you had to get involved at, and then if you can share, what was the outcome?
So I can't share the outcome. But
Attorney client privilege.
right, but I can tell you that it was John Singleton, his situation was unique because when he passed away, he left behind a mother and a child. Now the child is an adult, right? The child's an adult. And because of his he was affluent, right? He was affluent. I mean, we all we all knew the name John Singleton. There was no other one, right? Um, because he died with quite a huge estate, what ended up happening in probate court is his mother ended up going after his child for part of the estate, which is crazy because you're, as a parent, your natural heir, even if you are survived by your own parents or your children, your natural heir, your natural beneficiaries are your children.
Right.
So this is why you don't want to go to probate. And this is why you do want a plan in place, because you don't want to start an all-out feud in public like that, right? So the mom and the grandmother and the child were going at it, fighting over assets, right? And really where I came in is I consulted with his one of his younger heirs. And it's kind of sad that and this is such a thing in the minority community, where we don't really get smart about the things that matter until we get hit with the pain. So this young beneficiary, who's an adult, was coming to me, and I was talking to her about the importance of a living trust and getting this stuff in place, because she was living the nightmarish reality. I mean, she was getting a really messed up education. um, but yeah, and they're just, look, celebrities are just like you and me. They are just such average people in a sense, because a lot of them, I don't care if they're worth $10 million, $15 million, $76 million, they still don't understand the importance of putting an estate plan in place. And it's sad because they're at the top 10% of the wealth in America. And it makes me wonder, who are they, what intelligent people are they surrounding themselves with? Right? At what point does nobody say to them, "Oh, once you get your first million, maybe you need a power of attorney and a living trust," right? It's insane. It's insane. But that's all I can say about that.
No, perfect. But so we have some comments. People are like, "Wow!" And these are the types of things that pop up all the time. So, as a real estate agent, I often will tell my clients once they close on the house, "Hey, you might want to talk to an estate planning attorney, because now you have probably the biggest asset that you're going to have in your life." And some people are like, "Well, I don't think I want to pay for that right now." My advice is, if you don't pay for it up front, you're going to pay for it on the back end. And probate is way more costly than it is to start an estate plan. The other part of that is, I tell people, like, you never know what's going to happen, right? Lioness just told you she had clients that healthy, good bill of health. They were out, and all of a sudden something happened and they're incapacitated. Excuse me.
Yeah.
Well, I tell my clients all the time, if once you sign your loan documents, once you sign and make sure that, like, you are officially the new owner of that home, you are on the deed, it's been recorded. God forbid you are walking into your office building one day and get struck by a bus. What happens to the property that you just bought? The property that you've been saving up for, working so hard to acquire, spent sometimes months going to look for, had to go through multiple bidding wars to try to win this property. And you've probably depleted some of your life savings just to do it.
Yeah.
All that hard work has now gone out of the window, because guess who's going to control that property? If you're in the state that I'm in, it's going to be the state of California. So this is why I'm stressing the importance of getting solid, sound financial planning and estate planning for the month of March. All right, perfect. So Lioness,
Oh, I
really,
want to
really,
mention something. I want to mention something because I know you and I
absolutely.
talked about um, when, of course, when people first are buy their homes and they're like, "Well, I don't want to spend any money on a living trust," right? Fine, I understand. I've been there. I've been there, right? Buyer's remorse. I'm like, "Oh my god, right? What did I just do?" But remember, we were talking about, you're going to end up paying a mortgage no matter what. It's either your own or it's going to be somebody else's. Okay. The thing about investing in an estate plan, and I say
Wait a minute. Stop,
invest.
stop right there. I don't want to interrupt you. Did you hear the word that she used when she talked about estate plan? She did not use spending. She used the word investing. So this is part of the mindset I want you guys to get that shift in. You're not spending, you're investing. All right. I'm sorry. Go ahead though.
No, you're right. You're right. It is a mind shift. It is absolutely. The thing about investing in an estate plan is you are protecting your wealth with the idea that you are trying to create generational wealth, right? Because that's what the power of real estate can do for us and the generations behind us that come after us. I say the word invest because even homeowners that are like 15 years in, have lived in their home for 15 years, are really quick to say, but why do you charge those legal service fees? Because I found an attorney that charges $500. Or they won't even say an attorney. I went to some place and they charge $8.99 or $6.99. And I'm like, there's no attorney, a real one. There is no real attorney in life that will accept $6.99 for you to protect your $1 million home. Where you went is you probably went to a financial professional, not even a certified financial advisor, a financial professional who probably holds a life insurance, who's probably has a life insurance certificate or something like that. Or you went to a paralegal. It always blows my mind that people want to protect, right? Retirement accounts, life insurance policies, bank accounts. They want to protect their home, but by the time we get down your list of assets, you're probably worth a lot more than you think. $2 million, $3 million with a $1 million life insurance policy. People want to protect this, but they're okay with, they can sleep at night knowing I've spent several $100s, or I did a fill in the blanks myself and they became their own estate planning attorney. Blows my mind. You are not affording yourself the type of protection that your family needs. And I can tell you, because I've retained these people. Cheap is expensive. It ends up being expensive in the long run. And I know this because I retain like maybe 30 to 40% of my practice is retaining people that went to the wrong place the first time. And that kills me because I'm looking at a trust that was put in place 10 years ago, 15 years ago, and there's so many problems with these plans. And problem number one ends up being you went to the wrong place the first time. Red flags. I get red flags. My biggest red flag is I look at these trusts and then I do a title search and the house was never put into trust via a quit claim deed. So basically I've got a prospect thinking, oh, my kids are going to get my home. Everything's great. And then the home was never placed into trust. So really they've just kind of been gambling. And they've been thinking that they're okay, but they just are walking around with a piece of paper that means nothing. And their family is still going to probate, right? So you have to be careful. I know it's hard to sort of think like, well, it's another investment, but it matters. It matters. Like you can't shortchange your kids. You've already put so much sweat, blood, and tears into finding the perfect home. Or, you got to think about your estate plan as an investment.
Exactly. And Chris has a good he says it reminds me of the saying, you get what you pay for. I absolutely express that to a lot of people, especially people in my house. You get what you pay for. So don't try to skimp out on it. Let's see. On the same vein, so Janelle has a question. How much does a living trust cost on average?
You know what? That's a good question, Janelle. It really depends. It's like it's the favorite attorney answer. It
It
depends.
depends. Best
Um,
two words you're ever going to hear from an attorney. It
right.
depends.
Because it's I've got like um I've got firms that start charging at $6,000, $7,000, right? I've got firms that start charging at $2,000, $3,000. It just depends. But I can tell you that none of those numbers are wrong, especially if you're dealing with an attorney. I think the the best place to start is make sure you are dealing with an estate planning attorney. That's the best place to start. Why? Like I said, people are comfortable with their life insurance agent drafting their power of attorneys. People are comfortable with whoever, right? Just buying the Susie Orman CD and doing it themselves. But the best place to start is talk to an estate planning attorney. And then you have to think about, once you found that attorney, is that the attorney that you want your loved ones to have a relationship with? Because yeah, it's your plan, but once you start, going through your decline in health, once you start suffering cognitive dysfunction or disorders, your kids are going to be the one calling up that attorney. Is that attorney the one that you want your kids to be dealing with, right? But I would start there.
And then she had a follow up question. Does it all depend on your worth? So does the cost depend on basically how much you're worth? Or I'm going to throw this in there. Does the cost really depend on what you want to put inside of the trust?
Right. So remember when I told you that the taxable estate for married people is just above 26 million, single individual is just above 13 million. So once you start hitting close to those numbers, your estate plan is going to be a little expensive, right? Because we have to start thinking about planning for death taxes. We have to start talking about, charitable contributions and charitable giving just to cut down on your tax bill at the end of your life. But the average person is not that, right? The average person is below 26 million, below 13 million. So you could have a $6 million estate, and your estate plan should cost as much as a person who has a $2 million estate, because we're not hitting that taxable threshold. Now, it also gets expensive if you've got a special needs beneficiary, right? Because depending on what assets are going to your special needs child, they may need their own special needs trust. So it just depends on what your life looks like. But most people, they all fall in the same category of just a typical estate plan.
And yeah, so earlier, so Janelle, kind of to piggyback off that point. So earlier, remember we talked about the investment of an estate plan versus the cost of probate. You see how I use those two words? The investment of estate plan versus the cost of probate. So I'll give you an example. I saw somebody spend $3,000 for an estate plan, and people thought that's absolutely crazy. Why would you spend that much money? Well, the cost of probate can cost you upward of 25, 30,000 plus. So would you rather spend the 2 or 3 thousand on the front end, or your heirs have to pony up 30 to 40,000 on the back end? So those are things to consider, right? Because when something happens to you, God forbid, and your heirs are grieving over your loss, but they also have to figure out how they're going to conduct the business of the estate. And then that cost hits them. That's not something that you want to pass down to your heirs. You want to pass down the liability. You want to pass down the assets. So again, we're talking about the investment in an estate plan versus the cost of probate.
Yeah.
We do have one.
Oh, I actually have a potential probate. Oh man, so this blows my mind. I've got $270,000 in an IRA. No beneficiaries. None. Okay. We're not talking about a house. We're talking about a financial account. And because it's over $184,000, guess what? Fidelity's making me go to probate. So let's keep that number in mind. $270,000. Okay. So what that amounts to is $8,400 goes to me when this is done. And I didn't choose that number. Attorney's fees are statutorily determined based on the value of the estate. Because I hate probate so much, I would charge the client $18,000 if I had it my way, but I only get $8,400 of that. Another $8,400 goes to the court-appointed personal representative. They can waive that. Most people don't because they have to work, I have to work, they have to work, right? So now that's $8,400 times 2 that's being chipped away at this $270,000 IRA. And then we have to think about the $1,500 that go to publication and filing fees with the court. $1,500, okay? I'm not done. And then we have to think about the bond because most of the time, whether a personal representative is given full authority to run the show and do what they need to do to move this probate process along, or whether they're given limited authority, most of the time, probate court will make the personal representative post bond, right? And it's just a lot eating away at this $270,000, right? I think when all is said and done, we'll probably be out $20,000. And this is because it's a financial account, it should be a shorter process, maybe a year and a half. But that's what we're looking at. So if that's a financial account, think about what happens when we've got a house in Southern California, right? Where what? I think the average is like at least $700,000 now.
700,000. Actually, we're probably at about 750, 760 median home
Okay.
price.
So $750,000. What if a $270,000 IRA account is going to put you out a year and a half of your life and 20 grand? What do you think a house is going to do to you?
It's
Right?
going to put you out a big chunk of money, and that process takes a long time, especially if it's limited authority. There's so many steps that you have to take before you can even get to the house being on the market. So, and it's designed that way so that there's a certain number of days that you have to do this, a certain number of days that you have to do that, a certain number of days that something else has to happen. So it's designed for it to take a little bit of time. So, and all that time is costing you. It's costing you.
Yeah. And it's not fun. I mean, this is why I love estate planning so much versus probate because my clients are happy. Once we go through the process and they're like, this isn't as bad as I thought it would be. Then the process is done and they're like, oh my God, I have peace of mind. And then probate clients are just unhappy. They're just, I mean, why would you be happy about going through the court process? Like it's yeah.
It's a lot. And even in terms of the real estate piece of it, right? If you go through limited authority probate, when you put your house on the market, you don't get to just dictate the price. The court kind of dictates the price. And the process is not just you put the house on the market, somebody makes an offer, you agree to the offer, boom, bam, bip, it's a done deal. You have to go to court, and the offer that you accept essentially sets the court date. Then anybody who decides that they want to purchase that property can come in and bid at that time. So the process can take a little bit longer. Let's see. This is an interesting question. So from Cheryl, what happens if your kids live in a different country? How do you make sure your kids get your inheritance?
So this kind of goes back to the talk that we had about choosing the right successor trustee. So first of all, it doesn't matter where your kids are. They are not precluded from inheriting American property from you or American dollars It doesn't matter where they live in this, in any country. What matters is, did you pick the right person to let them know once something's happened to you that they are starting the administration of your estate? Because that's, a lot of people miss that too. Like, once we put a living trust in place, once my clients pass away, the trust has to be administered. Parts of the estate have to be distributed according to your intentions. And part of the success of a trust administration is making sure you put the right person in place to let the beneficiaries know they've got an interest in your estate, and keep them apprised of what is going on. Oh, I just got a check from the life insurance policy people. Oh, we've got to hire a CPA to do the final tax filings, things like that. So you ensure that your beneficiaries get their inheritance by putting the right responsible people in place.
Awesome. Let's see. We have another question. This one is coming from Marcus. What are the complications of buying a house from an owner that has a quit claim deed?
That's a
So yeah, this is very interesting. So the owner, I just want to make sure I'm understanding this. So the owner has a quit claim deed. Are they the person who the quit claim deed was administered to? So I guess I just need some clarification on that. Are they the owner and are putting a quit claim deed on the property, or did they get a quit claim from the owner and they're now the person that's on title? So maybe can you be a little bit more specific to your question, Marcus? Because the answer might vary depending on kind of how this is set up. But even on that note, perfect segue. So I'm gonna wait for him to respond. Um, what? Because being in California, I don't know how this works in other states because I'm not licensed in any other state but California. Sometimes people will say, "Oh, I don't need a trust. I don't need a will. I'm going to quit claim this property over to my son or my daughter or my grandson or one of my grandchildren." Can you explain? There could be pros and cons to that situation. So can you kind of just walk us through what the pros and cons
I'm
are by
biased.
quit
There's
claiming a
only
deed over to
cons.
a relative?
I'm biased.
I'm trying to be nice. I'm trying to be nice.
Okay, so there's two scenarios, and I get confronted with this all the time. There's two scenarios. I don't want to engage in thinking about my own estate plan. Thinking about being ill or thinking about dying is not a very pleasant thought to me. So what I'm gonna do is I'm gonna put my kids on title with me. It happens all the time. Okay, the problem with putting your kids on title with you is that if they don't live with you, and most of the time, adult kids will not live with their parents because they've already got their own lives either in another state or they own another home, whatever it is, you may trigger a property tax reassessment. And we were talking about this. I had a lady and she had 4 kids. They all did not live in the state of California. So she did not want to do a trust. She just wanted to put all 4 kids on title with her. And she triggered a property tax reassessment for 80% of the fair market value of the house in 2022. She did this 2 years ago. And the problem with that is her taxes went up. She was really sour about it. So by the time she got to me, and I was like, "You have a problem that I cannot undo," right? Because even if she did decide to get smart and say, "Oh, I want a living trust now," there's no undoing that 80% reassessment. There is no going back, right? So that's one scenario. And even if let's say you didn't like your kids, but you put your grandbaby, your 19-year-old grandbaby on title with you because you did not want to do a living trust. don't trust your children, but you trust your grandbaby, put her on title with you, that will also trigger a reassessment because the exemption for transfers between grandchild and grandparent don't get triggered when you still have living children. You still have natural heirs that should have inherited from you, but because you hate them and you're in favor of your grandchild, um, half of that house is getting reassessed at current fair market value, right? So that's never a good idea. Another one is I know we spoke about this, the ladybird deeds, right?
Yes,
They're
yes.
not they're not honored in California. I don't know what my hair is doing.
It's only
They're
it's only 5 states, and California is definitely not one of those states.
We have a version of it. We have a version of it, and it is called a transfer on death.
TOD, right?
Transfer on death deed. Okay, and this one hits close to home because it actually really did happen to me. My mother-in-law transferred her condo to my husband via a transfer on death deed, and it worked out in our favor because my husband did survive his mother. Did, right? The problem is that he's got more than one child, right? And um he cannot get away from putting a living trust in place. He just can't. So even if that's the road that you went down, somebody is going to end up putting a living trust in place. Now, we got lucky. We got lucky because what would have happened if my husband did not survive my mother-in-law is I would have had to go to probate.
Mm.
So
There's that word again.
right? The point of a living trust is that it ensures that someone will inherit your property. Someone. It could be your kids, it could be your grandkids, it could be your favorite niece or nephew, it could be a charity, right? Or a nonprofit. And I say that in line because I usually have a plan A through D for my clients because life happens. I have clients that come to me and I become sort of, fearful that they don't come back in 10, 15, 20 years when life changes, but at least we'll have a plan D. We could go through all of it. With the transfer on death, if the designated transferee does not survive you, that's not an avoidance of probate, right? And that's the whole point of investing in a plan is making sure that your estate goes to somebody, anybody of
You
your
want
choosing. You
to
choose.
you want to avoid probate as much as you possibly can. I'm actually having conversations with my father who lives in Florida. That's where this whole ladybird deed situation came up. And I was telling him, like, you have to set up a plan, because if you don't set up a plan, me, your two daughters, we have no idea how that's going to get divvied up. So you need to set the plan up, and your will alone is not going to cover it. So you need to
No.
set up an estate plan, put your will inside of that piece so that it's ironclad and everything works out. I'm going to
Yeah.
go back to Marcus's question. So Marcus, I don't know if you heard what we were saying, but I'm going to tell you one of the complications that can happen from purchasing a house with an owner that has a quit claim deed. So a quit claim deed just kind of assigns, I guess you would say, rights to that property to whoever they're assigning it to. However, let's say, for instance, that this person now wants to sell with somebody else on title. They're going to have to go and either get that person off of the deed, or they have to be part of the sale. So they would have to be a part of any purchase agreements that get written up, anything like that. So it wouldn't just be just the owner, it'd be the owner and anybody else who was actually on title on that deed. Now, the process to get somebody removed can be a little bit tricky. Like, I'm dealing with a client right now who's having this exact same issue. They bought a house. Well, her mom bought a house back in the 90s, left it to one of the daughters. But when they purchased the house, they put two people on the deed, And so when they went to go figure out, like, we want to sell the house, they had to go back to those two people. Well, one of the people they couldn't find. So now you're tying up more time just trying to find this person. So they had to go to court. The court issued them an order. They were like, okay, Dietric, we're ready. I said, let me contact the title company, let them run a title search. And what do you think the title company found? They found that person who they couldn't find, even though the court gave them a judgment, they couldn't find this person. The title company said, no, you have to actually get that person off of the deed. And if you can't find them, the court's going to have to sign the documents for it. So now they have to go back to court and go through this whole process again. This is one of the problems of putting somebody else on the deed if you're the owner. And if you're somebody who's looking at purchasing, this is one of the potential problems that can come down the pipe. So I hope that answered your question, Marcus. If not, we can talk about it later. Let's see. All right. So great discussion tonight. I want to thank my guest, Lioness Ebbay, for joining us to talk about estate planning and the importance of it. Make sure you tune in next week. We're going to be talking about life insurance. So we went from estate planning. We're going to talk about life insurance. You'll be able to see how to tie all of this stuff in as we gear up to go into Financial Literacy Month. But Lioness, can you tell people where they can find you? I'm also going to leave it in the chat. So when this live stream is over, you'll be able to see, or in the description, you'll be able to see that information in the description. But can you tell the viewers how they can locate you or talk to you if they have questions?
Yeah, absolutely. I welcome all of you to email me. My email address is attorney@lionnesslaw.me. You can also reach out via phone. I've got a San Diego mobile number, but I'm here in LA County. It's 619-245-5688. I do like to give free consultations, only because a lot of people just still don't understand the importance of this. I get a lot of hesitance. Like, this is all I have. I just have a house. Can I just do a will? Or why can't I just pay you for a trust? Because I don't want to pay for power of attorneys. And it's really important, really, for us to, get to know each other, especially if you're looking for an estate planning attorney. It has to be the right fit. So feel free to reach out. I don't bite. But yes, thank you so much, Dietric, for letting me come on this evening. Really engaging talk. I can do this all day with you.
Awesome. Appreciate it, Lioness. Once again, everybody give a big thumbs up, put some fire emojis in the chat for Miss Lioness Ebbay and the great information that she provided us tonight. Again, I want to thank you guys for tuning in. I want to thank my guest, Lioness Ebbay, attorney at Lioness Law. She is practicing, doing her thing. And again, if you need more information on estate planning, make sure you contact her. If you have information or if you have questions on real estate related matters, please feel free to contact me as well. Once again, great discussion tonight. I really appreciate it. Make sure you guys tune in next Thursday at 6 p.m. as we'll be talking about life insurance. So we're going to have another great guest on to run us through that. And we're going to gear up for Financial Literacy Month. So I'll see you guys next week. Make sure that you like, subscribe to the channel. And again,